Good morning, everyone. This is Judge Stanley speaking. Welcome to the Office of Tax Appeals. This is the hearing in the appeal of Gabriner. I can't remember, Mr. Gabriner. Can you pronounce it for me?
You got it right, Gabriner. Yeah.
Okay, thank you. The hearing is being live streamed and will be posted on the Office of Tax Appeals YouTube channel. It's also being recorded and transcribed electronically. To ensure we have an accurate record, we ask that each person speaks one at a time and avoids speaking over one another. Speak clearly, loudly, and when needed, I may interject to ensure proper transcription. After the hearing, the Office of Tax Appeals will produce an electronic transcript upon request. If anybody wants to have one, they need to request it. Okay, so we're officially going on the record in the appeal of Gabriner, OTA case number 2407168885. The date is October 8th, 2025, and the time is 9:30 a.m. or close thereto. The Office of Tax Appeals is not a court. It is an independent appeals body which is staffed by its own subject matter experts. It's independent of any tax agency, including the Franchise Tax Board. The hearing is being held electronically by the agreement of the parties. Once again, I'm Judge Teresa Stanley. I'll be the lead for purposes of conducting this hearing. My co-panelists, Judge John Johnson, Judge Asaf Kletter, and I are equal participants in deliberating and determining the outcome of this appeal. I'm going to ask the parties to identify themselves and who they represent, starting with appellate.
Thank you. I'm Danny Gabriner, and I'm representing myself as the appellant.
Thank you. And Franchise Tax Board.
Good morning, Leo Cristobal, representing Respondent Franchise Tax Board.
Good morning, Alyssa Pinerbossi, also for Respondent Franchise Tax Board.
Thank you. As stated in the minutes and orders, the issue to be decided in this appeal is whether appellant's claim for a refund for taxable year 2019 is barred by the statute of limitations. Do you agree that that's the issue, Mr. Gabriner?
Yes, I agree.
And Mr. Cristobal?
Yes, I agree.
Okay, appellant submitted Exhibit 1. Franchise Tax Board, FTB, did not object to the admissibility of the exhibit, and it is admitted into evidence. FTB submitted Exhibits A through C. Appellant did not object to the admissibility of these exhibits, and they are also admitted into evidence. Does anybody have any issues with respect to exhibits at this point? Okay, seeing none. Mr. Gabriner, you indicated during the pre-hearing conference that you will testify today. So before we begin your presentation, I need to place you under oath so we can consider your statements as testimony. And you will remain under oath until the close of the hearing. Please raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You requested 10 minutes for your presentation, and you may proceed when you're ready.
Thanks so much, Judge Stanley, and the other judges for hearing this case. My case, I think everybody understands the basic facts that I had filed a return on May 15th, 2024, that the Franchise Tax Board claimed was beyond the statute of limitations. And I'm here to present why it actually was within the statute of limitations and that the Franchise Tax Board was in error. So the starting point for looking at the law here is the Revenue and Taxation Code 19306. Specifically, it calls out that no credit or refund shall be allowed or made after the expiration of 4 years from the last day prescribed for filing the return. There's been other language used, such as due dates and other ways of calculating, but I'm here to point out that the last day prescribed for the 2019 tax return was actually on July 15th, 2025. RTC 19306 also spells out that this should be determined without regard to any extension of time for filing the return. And I think there's been some confusion on this. I'm also here to point out that extensions and postponements are two very different things. And in this case, we are talking about the postponement that the federal government and the Franchise Tax Board agreed to. RTC 18572 adopts the Internal Revenue Code 7508A, which is the basis for the federal postponement that happened due to COVID-19. California follows the federal guidelines and has said so in press releases. The president did declare the disaster for COVID-19, and I'll get to that in a moment. Within IRC 7508, Section A1E, filing a claim for credit or refund needs to happen performed within the time prescribed. Again, it's using that language of time prescribed, not due date, that is referenced in the FTP's arguments and elsewhere. Treasury Regulation 301.7508A1, which speaks to the IRC 7508. Section B1 points out that the postponement period is supposed to be disregarded in calculating the time. So Section 1 points that out, and subsection I specifically calls out the performed in the time prescribed. Of the same subsection B, part 3, it specifically says that postponement runs concurrently with extensions. So again, it's pointing out that postponements and extensions are two different things. They run concurrently. There was an extension as well, but that's unrelated to the point here. And then part 4 says that the due date is not extended. It only disregards the time period when calculating. The FTB also pointed out this regulation and points out the part that says that other statutes may rely on the date, that when other statutes may rely on the date, postponement does not change the due date. And I'm not arguing that it did change the due date, but it did change the last day prescribed for filing the return. This part of the statute or of the regulation is meant to make sure that other aspects such as assessments, interest, credit, or penalties are not affected in a blanket manner. But this specific regulation in section C1V specifically calls out filing a claim for credit or refund as something that we should be disregarding the postponement period when calculating. The IRS in their notice 2020-23 specifically postponed the deadline for filing the 2019 tax returns to 2020. And then the FTB in their notice 2020-02, as well as in their press releases, confirmed that tax day and the last day prescribed for filing was July 15th. So back to the original central point here for 19306, when was the last day prescribed for filing taxes? It was July 15th. And so 4 years from that date would be July 15th, 2024. There's 2 cases that were already held on this matter. One was Pomren, which happened in February of this year. And the OTA specifically held that disaster postponements do extend the refund claim limitations period. In that case, following the same logic that I'm talking about here, the OTA ruled in favor of the appellant and the refund was allowed, even though it was beyond the original 4 years that one might consider. There was also a case that was referred by Judge Stanley with Nguyen. Within that case, one of the specific parts is that it's the taxpayer's duty to prove, to have the burden of proof that their claim was filed timely. And Nguyen did not do that. The only thing Nguyen did in their appeal was point out that with the COVID-19 pandemic, the original filing date was extended, but they did not point out anything related to the IRS notices, nor did they point out the language around postponement being different than extensions, or the specific calling out of Treasury Regulation 301.7508A1, subsection C1V, that filing a claim for a credit or refund is part of what needs to be, the time period needs to be disregarded. In one of the cases cited, Averill, it points out that refund statutes are to be strictly construed. So if we're to strictly construe this, we need to look at the actual language, which is the last day prescribed, and without regard to extension. And once again, this was not an extension, it was a postponement, which has been clearly pointed out as different. So once again, my filing for the refund happened on May 15th of 2024, which was within the statute of limitations, and is should be accepted. Thanks so much.
Thank you, Mr. Gabriner. Mr. Cristobal, does the Franchise Tax Board have any questions for Mr. Gabriner?
This is Mr. Cristobal. No, the Franchise Tax Board does not have any questions.
Okay, thank you. Judge Johnson, do you have any questions?
Ms. Judge Johnson, no questions for now. Thank you.
And Judge Kletter, do you have any questions?
This is Judge Clutter. I'm going to hold my questions to the end. Thank you, but no questions at this time.
Okay, thank you. Then we will move to Franchise Tax Board's presentation. They will not be presenting any witnesses, so nobody is going to be sworn in under oath or affirmation. Mr. Cristobal, the Franchise Tax Board requested 10 minutes for your presentation, and you may proceed when you're ready.
Great, thank you. Good morning. As mentioned, my name is Leo Cristobal, and I represent Respondent Franchise Tax Board, or FTB. As mentioned, the sole issue in this appeal is whether appellant's 2019 claim for refund is barred by the statute of limitations. The original due date for a 2019 tax return was April 15, 2020. In this case, appellant filed an untimely 2019 tax return on April 15, 2022. Since appellant filed an untimely 2019 tax return, California law provides that no refund shall be allowed unless a claim for refund is filed within 4 years of the original due date of a 2019 tax return. In other words, the last day for appellant to file a timely claim for refund was April 15, 2024. However, appellant did not file a claim for refund until May 15, 2024. Consequently, appellant's claim for refund is barred by the statute of limitations. Appellant has cited the COVID-19 state of emergency postponement that FTB provided to taxpayers in 2020. That postponed 2019 return filing and tax payment deadlines until July 15, 2020, and essentially argues that the original due date to file a 2019 tax return was changed to July 15, 2020. And therefore, the 4-year statute of limitations period should not have expired until July 15, 2024. Unfortunately, and as outlined in FTB's briefing, the law explicitly provides that the original due date of a 2019 tax return never changed. Although 2019 returns were considered timely if filed up through the postponement date of July 15, 2020, their original due date remained April 15, 2020. Accordingly, if a taxpayer filed an untimely 2019 return, the last day to file a timely claim for refund under the law remained April 15, 2024. Now, this understanding was solidified in the presidential opinion of Wynne, which is an OTA case, as previously mentioned, that was decided after this briefing, after the briefing in this appeal was completed. In Wynne, the taxpayer filed an untimely 2019 tax return claiming a refund on May 9, 2024. The taxpayer cited the COVID-19 postponement and argued that the 4-year statute of limitations for a 2019 claim for refund should expire on July 15, 2024. However, the OTA disagreed and explained that FTB's postponement did not change the original due date upon which the 4-year statute of limitations period for 2019 refund claims is based. The OTA held that the 4-year statute of limitations period expired on April 15, 2024, and that the taxpayer's claim for refund filed in May of 2024 was untimely and barred by the statute of limitations. In this case, appellant similarly filed an untimely 2019 return and failed to file a refund claim until May of 2024. Just like the taxpayer in Wynne, appellant's return was untimely and his refund claim was filed outside of the applicable 4-year statute of limitations period, which expired on April 15, 2024. Accordingly, appellant's claim for refund is similarly barred by the statute of limitations. FTB notes that the Pomeran case cited by appellants does not control in this situation. That case dealt with a different disaster postponement, California winter storms, that overlapped with the final expiration date of the SOL period to claim a refund for the 2018 tax year. In contrast, the issue both in this case and in Wynne is the COVID-19 postponement, which never overlapped with the final expiration date of the SOL period to claim a refund for the 2019 tax year, and therefore did not change the last day for appellant to file a timely refund claim, which, pursuant to applicable law, remained April 15, 2024. Since appellant's 2019 refund claim was untimely filed after April 15, 2024, the claim is barred by the statute of limitations, and FTB's action denying that claim should be sustained. Thank you, and I'm happy to answer any questions you may have at this time.
Thank you, Mr. Cristobal. Judge Johnson, do you have any questions for the Franchise Tax Board?
This is Judge Johnson. No questions at this time. Thank you.
Judge Clutter, do you have any questions?
No questions. Thank you.
Okay, so Mr. Gabriner, I'm going to give you 5 minutes for any rebuttal or final comments that you want to make, and you may proceed when you're ready.
Thanks so much, Judge Stanley. In Leo Cristobal's statements, he brought up the original due date, I think about 6 times. Original due date is not the language that's used in the statutes, so I'm not sure why we keep referring to the original due date. Also, by the logic presented with the Pomeran case, although it was a different disaster and a different time period, using the logic that he provided, that case would have ruled in the other direction, because the, again, original due date of that case, 4 years, the statute of limitation would have barred the appeal. So again, I have a problem with the phrasing of the original due date when that's not the language used in the statutes of the last day prescribed for filing. Also, the difference with the Nguyen case, although it's very similar in terms of what happened, we do have slightly different facts of when the returns were filed and so forth. But the difference in the Nguyen case is that Nguyen did not provide the burden of proof to show their timely appeal. And because they did not show that burden of proof, the Franchise Tax Board's mistake was sustained and the refund was not granted. But if Nguyen had provided the same level of evidence, including the statutes, the regulations, the notices, and the precedent, then the OTA in that case likely would have responded in a similar way to how I'm requesting right now, that the refund was filed timely due to Treasury regulations that specifically call out that filing a claim for credit should be that the time prescribed should disregard the postponement period, should disregard the period from April 15th to July 15th when we were undergoing a global pandemic, and that was a federally declared disaster. Thanks so much.
Okay, and that concludes your remarks, Mr. Gabriner?
Yes.
Okay. Judge Johnson, do you have any final questions?
Judge Johnson, yes, thank you. Mr. Gabriner, you mentioned extensions and postponements are different, not the same thing. I agree with you there. I do have a question. Extensions for California purposes are not considered when calculating the claim for refund statute of limitations period, but you believe postponements should be considered for that? Can you describe why, even though they are different, why postponements and extensions wouldn't be treated the same when it comes to calculating statute of limitations?
The statute, the RT 19306 specifically points out that extensions are not calculated. So for that reason, they can't be. If there's an extension, whether it be an automatic extension or any other form, the statute is very clear that you do not count from the extensions. But the postponements, which several times in different statutes and regulations are pointed out are different than extensions, in this case do move the last day prescribed for filing. Specifically, the language from the IRS Notice 2023-21, the IRS on this very same issue for federal refunds specifically pointed out that that same time period should be disregarded when calculating. So although we're dealing with the Franchise Tax Board case here, on the IRS side of things, the time period was adjusted due to this postponement, and the Franchise Tax Board should be following the federal guidance on this. So yes, that's why I believe that they are very different things.
Okay, thank you. And I'll get to the notice as part of my next question, but before that, you mentioned following the federal guidance. So the Treasury regulation that was at the briefing 301.7508A-1, subsection there B4 says that postponements do not extend the due date. They merely allow IRS to disregard a time period. So I know that 19306 on the state side is silent as to postponements, but we should follow federal guidance, and the federal regulation is kind of explicit. It says that postponements do not extend the due date. So outside of Notice 2023-21, do you think that the coded postponements would have extended the due date for filing a claim for refund?
If the notice hadn't happened, would it have? Is that the question?
Correct. Yeah.
The regulation, the notice clarified because the Treasury regulation states that additional clarity should be provided. And so that's what that notice did, is it went back to the Treasury regulations and specifically clarified the points that were made. But the original regulations also do point out that the postponement period should be disregarded when specifically performed in time prescribed. It's the exact same language that's in RTC 19306, the time prescribed, and then specifically calls out in section C1V, filing a claim for credit or refund. In one of the STB's arguments, they pointed out that the line that says when other statutes may rely on the date, the postponement period does not change the due date. That was meant to provide, to prevent blanket changes of any other regulations. But in this case, the statute itself says that filing a claim for refund is included in this time that should be disregarded.
Okay, and then let's go to the notice then, 2023-21. So in that notice, and it's very specific just for the IRS notices related to the 2020-2021 COVID postponements. So in the middle of page 3, there is a paragraph and it says, although those notices postponed certain return filing due dates, those notices did not extend the time for filing the returns because a postponement is not an extension. That kind of goes to your point. Postponement is not an extension. I would point out that for federal purposes, they do automatically include extensions when calculating the statute of limitations. California specifically says we don't include extensions. So there's a slight distinction there. But I would note that even though the IRS includes extensions when calculating statute of limitations, that next sentence in that notice says, as a result, the postponements did not lengthen the look-back periods under IRC section 6511, which is the time for filing a claim for refund. And it goes on in the next paragraph and it says, absent the relief granted in this notice, taxpayers who do not receive an extension would have 3 years to file their claim for refund from the due date of the return. And it says generally April 15th, 2020. So to me, it sounds like the notice is saying if it weren't for this notice, the postponements would not have extended the statute of limitations for filing a claim for refund. But this notice does provide that you do include the postponements. Does that sound in line with your reasoning as well? And then, yeah, where would you go from there?
I hear what you're saying, and I think I'd have to look a little bit closer to see that. I would point out that in that same notice, it specifically says that the period beginning on April 15th, 2020 and ending on July 15th, 2020 will be disregarded in determining the period for filing a claim for credit or refund of any tax. And so, although I'd have to look back to see, again, as you're saying, if this notice did not exist, how would the regulation work? I still believe that there's enough language specifically pointing out that there should, that the last day prescribed is different and that, again, extensions are not postponements. But specifically, this notice lays it out even clearer that that period should be disregarded.
Okay, thank you. And the end result, as you read there in the grant of relief, was basically, no, do include that postponement period when looking at the due dates for claim for refunds down the line. And you agree that, or you would say that California should conform to that notice?
Absolutely.
Okay, let me turn it to the Franchise Tax Board side then. IRS issued notice 2023-21. Did California issue a similar notice?
You're asking me if California issued a notice in 2023?
Oh, I was flipping it over to the Franchise Tax Board.
Sorry.
Apologies, Judge. Let me just double check here. And I'm not aware of California issuing a similar notice, Judge Johnson.
Okay, thank you. Yeah, I didn't find one myself, just double checking. As far as California conforming to federal law where applicable, would California or should California conform to an IRS notice like this?
Judge, I'm not at liberty to answer just overall whether California is required to conform to a notice like this. Unfortunately, I have to, discuss what is available, which is, we don't have our own California notice, and so the IRS notice here would serve as guidance for California.
Okay, and maybe it's not a question you need to answer, but I just wanted to give you time to speak about the notice itself. Okay, I have no further questions. Thank you.
Thank you, Judge Clutter. Do you have any questions for either party?
I do not, no. Thank you.
Okay, I just have one clarification question for Franchise Tax Board. Mr. Cristobal, you mentioned that the 2018 deadline overlapped with the winter storms, but that the the COVID disaster did not overlap. I think I know what you mean by that, but could you please explain what the overlap is?
Yes, Judge. So I know you're referencing when I mentioned the relief that was discussed in Pomeran. So in that case, it was the winter storms and 2018 tax returns, a claim for refund on the 2018 tax year. It would have expired. The SOL period would have expired during the same relief period that the California winter storms was addressing. So that's the distinction here is that, if you think of just the 4-year SOL period and when it's about to end, that date fell within the time that the winter storms disaster postponement, was addressing. In contrast here, you could think of the 4-year statute of limitations period for the 2019 tax year. We're looking at the beginning of it, which is when the COVID-19 postponement relief. I should say the COVID-19 postponement relief was for April 15, 2020 to July 15, 2020. So it's a distinction as far as where the relief, the dates of the relief and the dates of the SOL periods.
Okay, thank you. I don't have any other questions, but Mr. Gabriner, you have a question?
It's less of a question, and I'm not sure if I'm allowed to address the point that you just asked, Leo Cristobal.
You want to speak to that?
Yes.
Sure. Go ahead.
Yeah, and just pointing out that yes, there is a difference in the Pomeran case that that the disaster in that case happened in the very time period that the claim would have to be filed to be timely, whereas in this case it happened at the very beginning of the time. Regardless, my point is that time period per the disaster relief is supposed to be disregarded. And so whether it happens at the beginning, at the middle, or the end, it appears that it should be the same form of relief. Yeah.
Okay, thank you. Since none of us have any additional questions, I want to just thank everybody for participating today. I commend you all for being so well prepared for this. And the panel will meet and deliberate and decide your case. We'll issue a written opinion within 100 days. And the Office of Tax Appeals is now in recess. The next appeal will begin at 1 p.m. Thank you all. Enjoy the rest of your day.